Welcome back. This is Roger Royce, host of the 10,000 Startups podcast, where every week we bring you original content on legal issues of interest to startup companies. And today I'm just really excited about the topic we're going to cover. It's something that you as a startup entrepreneur might not think immediately is your problem, but trust me, it is. And you're going to hear about it and hear about some of the issues that you need to think about it. And if you're one of the attorneys that listens to this podcast, you should pay particular attention because we're going to talk about ethics and professional responsibility, especially around the issue of who is the client when an attorney undertakes to represent a startup and all the problems that can happen when that attorney-client relationship gets to be a little bit fuzzy. So we have today Neil Wertlieb. He's a former general counsel and retired partner at Milbank, which was my old firm from way back when as well, coincidentally. He is also adjunct professor both at UCLA School of Law and at Berkeley, and a senior advisor at Harvard Law School Executive Education. So it's a professional development education program. I've known Neil a long time. He is a nationally known authority on legal ethics. This is a topic that we've talked about before. I think it was about 8 years ago. We were on a panel for the American Bar Association. So we're sort of going to revisit the issue here, but in a little bit more targeted manner. So thanks for being here, Neil. I appreciate you taking the time to come talk to us.
Thank you, Roger. It's quite an honor to be back.
So before we get started, I know you get this question all the time, but I didn't know you lived in Pacific Palisades until I was looking at your bio. First of all, I hope you're all right and you came out of the recent fires okay.
Yeah, we did. My house is still standing. My office, which was in the downtown portion of Pacific Palisades, the building just burned down. So I've had to change office addresses as well as my home address. Maybe one of these days we'll be back in the house, but it's in a very badly damaged area, like so much of the Palisades. So unclear when that'll happen. But thank you for asking.
Yeah, well, I'm glad you're okay. So let me kind of jump right into it. So the typical scenario um, and I run into this, I bet every day, where founders will come to me or individuals will come to me, and there might be more than one of them, or there might be one, and they'll say, look, we've got this brilliant idea. It's going to change the world, and we need to form a company. And we'd like you to do that for us. And so I will go ahead and form a company and I'll sign my engagement letter on behalf of the company and we're off and running. So the question and right immediately the ambiguity starts because they come to me when there is no company and ask for legal advice. And then we form a company. And I know that if I don't make it super clear to them, they're not really going to understand who I represent. So let me ask you, given the facts that I've just laid out, which again happens all day, every day, who do I, as the attorney, represent here? Am I representing a company or am I representing the founders?
It is a great question, and I'll say I've seen this come up dozens, if not hundreds of times in my practice as well. I worked with a lot of early stage companies, startups, working with founders. Um, it's such an interesting question because the founders, and there could be one, there could be multiple. They come to you as a lawyer, expecting that you're going to help them perhaps form the entity, but with the idea that you're going to be the attorney perhaps for the business, maybe for them, maybe they're not thinking about it clearly. But we as lawyers, we are duty bound to understand the scenario, to address that, and to be able to clearly identify who our client is. And I think this is an issue that a lot of transactional attorneys in the startup space don't give enough thought to. So to answer your question, it really depends. I think the founders probably and the attorney probably have the expectation that the attorney-client relationship is going to be between the attorney or the attorney's law firm and the entity that doesn't yet exist. And the notion of a non-existent entity being a client of a law firm is kind of absurd. So it needs to be broken down into components. And probably the best answer, and I'll keep coming back to this, is to have the conversation with the client or clients or entrepreneurs or founders, whoever is coming into your office as the attorney, have the conversation with them and make sure everybody's on the same page as to who is and who is not the client.
Yeah, and then I know people are out there thinking, well, why does this matter? And and I'm reminded of the movie Social Network. There's a scene in there where one of the founders of the social media company is in a deposition, and he had signed away a bunch of rights. And the attorney said, well, you know, if you didn't know what you were signing, why didn't you ask your attorney? And he said, I thought I was asking my attorney. I thought the company counsel was my attorney. Turns out they weren't. And the thing is that really happens. That absolutely really does happen every day.
Yeah.
That's why it's so super important, for people to know. So let's go back to the idea of representing the non-existent client, because I've seen like two schools of thought on this. One approach is we're going to sign an engagement letter to represent a company to be formed. And after that company is formed, it will then ratify the engagement. And that way we never touch the founders. We never represent the individuals. And we just start off representing company. The other way is I've heard lawyers say kind of what you said. It's kind of absurd to think you're going to represent an entity that doesn't exist. And that entity didn't come talk to you, an individual did. So you have to start off representing the individual. And then you form the company on behalf of the individual. And then you terminate the representation with the individual and start a new representation with a conflict waiver of the company. That's the second school of thought. And to me, you're the expert, so I'm going to ask your opinion on this. But kind of my gut reaction about this is that we're being a little overly metaphysical in that scenario, because when the smoke clears, we all know that we're just engaging a lawyer for the company at the end of the day. So can't we just have one engagement letter that says that and everybody acknowledges that?
Well, it depends what the engagement letter says,
Ah,
but there are and how detailed it is. But one of the problems that comes up somewhat often is you have multiple founders. It's easier when you only have one, but if you have two, three, or more founders, their interests are not necessarily aligned from a practical perspective. Maybe one founder is contributing a brilliant concept or intellectual property. Another founder is contributing money. Another founder is planning on contributing his or her time. And their interests are not necessarily aligned because they're doing different things. Their interaction with the business and with the other founders is different. Um, and the choice of entity may be a factor that affects the various founders in different ways. Is it a pass-through entity for tax purposes? Is it a corporation? Where is it incorporated? And that may be dependent on the particular interests of one or more of the founders. So if the lawyer, as they should, if they're taking that into account in advising the group of founders as to the type of entity, where it's located, where it's incorporated or formed. They are, in effect, providing advice based on the individual interests of the founders, which may lead any or all of the founders to believe, and reasonably so, that they have formed an attorney-client relationship with the attorney, or that they're receiving legal advice in their individual capacity from the attorney. The attorney, on the other hand, I think commonly would think, if they thought about it at all, would think they're being engaged to represent this business, and when and if it's formed, that will be the client and the only client. And I think you've got a group of prospective clients or potential clients who may reasonably believe otherwise. And that's why it's critically important to have these conversations up front.
Yeah, and the reason that I sort of thought about this topic is because the American Bar Association just issued a formal opinion in January of this year. It's 10 pages long, single spaced, and over what I would think would be, I don't know, I guess you might have thought it would be a more straightforward topic because the name of it is A Lawyer's Obligations When Advising an Organization About Conduct That May Create Legal Risk for the Organization's Constituents.
Right.
Well, that covers a lot, and that's pretty much right at the heart of the startups we're forming. And you've kind of touched on something. So back when I first came to the Valley in '91, I guess, I was doing a lot of partnerships. It's before we had qualified small business stock. It's before it was there was just way more partnership before we had an LLC statute, way more partnerships than corporations or more partnerships than there are now. And I remember we would have these big elaborate engagement letters that would try to go through and say, that would warn people and say, look, we're going to balance the interests of the parties here because you actually have a contract among a bunch of different constituents. And some of you have different risk appetites, some of you have different interests. And really, you're advised to seek your own counsel. But that's just not a practical solution in the startup
Right.
world. I mean, they're having trouble enough paying for one lawyer to draft the contracts. So yeah, I can advise them all to get their own counsel, but at the end of the day, I think no matter what the papers say, the constituents, the founders, the shareholders, they're expecting company counsel at the direction of the company to look after their interests. And I don't know how you resolve that conflict. I don't know how you get around it other than maybe what you said is to just have a fairly extensive, detailed discussion about what all the interests are, you know?
Yeah, there are a number of different ways to engage in this, and we can talk through some examples. But I do think that it's critically important for the lawyer to engage with the founders and talk it through, because if the founders and the law basically says the law governing lawyers basically says that an attorney-client relationship can be formed by contract, and it could be uh, either express, that is, a formal agreement, or it could be implied by the circumstances. So if one or more of the founders reasonably believes that they're receiving personal legal advice or that they have an attorney-client relationship with the lawyer, you as the lawyer, therefore, have duties that are owed to that individual. Maybe to protect their confidential information. You've got a duty of loyalty. You may have attorney-client privilege communications, which can't be shared with other founders without the consent of that one founder. It gets so complicated if you don't have the discussion. And one of the ways to handle it is to simply say, I may provide generic advice on how founders could interests might be affected by the choice of entity or where we incorporate or various items, but I am not representing your individual interests. My engagement will be with the company, the business entity, once it is formed. And if it is never formed, I do not have an attorney-client relationship with anybody. And when and if it is formed, that is my only client. And the individuals are not former clients, because we never had an attorney-client relationship. So I therefore owe you no duties. That's one way to handle it. And maybe in some ways, the cleanest and easiest way to handle it, because the lawyer only has one client. But the problem with that is, what happens if you spend a lot of time as the lawyer looking through the tax consequences, preparing documentation, writing a partnership agreement if it's a limited partnership, all kinds of work. And then ultimately the entity never gets formed. Who's going to pay you for your services, right? And what you've been spending months working on this, and the end, and your client never existed and still doesn't exist. Um, that's a
Yeah,
tricky one.
yeah. Well, we take a little risk on it, and believe it or
Definitely,
not,
definitely take some risk.
I think that might be sort of the one of the easier of all the scenarios, I think. Let's suppose we get past that and everybody agrees, lawyer for the company, and we do form a company, so yay.
Yeah.
Now we got a client that exists. But now the founders maybe start to squabble or get into a dispute, or not even a dispute. Let's say they have a transaction or any sort of conflict. And I see this happen all the time, over and over and over again. In fact, it's probably more normal than not to have the company get formed and they're going to reshape their cap table somehow. We're going to redeem out the founder. Maybe the VCs come in and they fire the founder. Or maybe the founder wants, maybe there's a secondary and we're not a transaction and we're not going to treat everybody exactly the same. So there's some little conflict between the company's interest and the founder's interests. So now it becomes critically important that we've established who the client is, right?
Yeah, who the client is and who the client is not, right? Because if the entity is your client, and none of the founders or directors or officers or anybody else is or was a client, then you really don't owe fundamental duties to those individuals. If they're a current client, you can't be adverse to them without basically getting their consent. And even if they were the original clients, so now they're perhaps a former client, you still owe certain duties to them. They're more limited, but you still owe duties to them, and being adverse to them on anything that really touches on the work that you've done on behalf of the entity, or you're doing for the entity that touches on anything you did for them, creates a conflict of interest with respect, potentially creates a conflict of interest with respect to a former client as well.
Yeah, I'm going to talk about that specifically in a second. But, I just have to comment. It just always surprises me how that's a concept that lawyers understand pretty well, but non-lawyers, they really push back against that.
Yeah,
And in fact, I heard it said, I remember talking to one VC, actually he was on a panel, and I heard him saying that when he invests in a company, if company counsel is on one of a certain set of law firms, he won't even hire a lawyer. He'll just rely on company counsel. And so that's sort of a layman's view of this, but a lawyer would hear that and say, are you nuts? I mean, company counsel doesn't care about you. In fact, their legal obligation is to focus just on the interests of their client. So,
exactly.
so there's a disconnect between what the lawyer's obligations are and what the public, I think, perceives our obligations. And I guess the best we can do is just try to explain to people that we're not all, yes, we're all going to get along and, we're all in the same boat here, but keep in mind, we have legal obligations to someone other than you.
Yep.
So on that, so there's a famous case that you and I talked about the last time I saw you on the panel. That's how long it was. And I won't mention a law firm, but I will kind of summarize the facts here because this is every corporate lawyer's nightmare. Individual comes along to the law firm and says, hey, brilliant idea. We want to incorporate it. And it's me and my buddy. And individual has a pre-existing relationship with the law firm, so he kind of leads the charge. They formed a company, two founders formed a company. Founders have a falling out. We buy out one founder, and that founder, he gets bought out, goes across the street, forms company number two to compete with company number one, and uses the same law firm. Okay, in that case, the founder, one of the founders of law firm number one, who did not form a competing law firm, sued the lawyer for malpractice and said, look, I'm your client, and you really breached your duties to me by forming that competing entity. And I know I'm probably playing a little loose with the facts here, but because I want to get to the central issue, the court in that case said, no, whatever that lawyer did that was wrong, he didn't do it as your attorney because the engagement letter says that the company is the client and not you.
Right. Right.
You know which case I'm talking about, right?
I know exactly which case you're talking about. And we had a similar conversation 5 years ago about the same case.
Yeah. Well, comments on that.
I think the there's probably, well, first of all, I think the facts of that case support the notion that that individual who was bringing the the complaint, the claim, was not a client individually. He might have believed he was, but reasonably, I think the facts are a little bit unique because in what actually happened was um, an entity already existed when the law firm was hired. So when they say we're representing the entity, there was a different form of entity. They effectively changed the nature of the entity to suit the needs of the client of the not clients, the founders, and their advice. So they had the benefit of being able to point to a pre-existing entity rather than having to deal with the messy situation of having two co-founders who came to the law firm and said, "We want to form an entity." Now, that's sort of the facts of the case,
Mhm.
that it really was the two individuals, and it's unclear that the law firm even knew that there was a pre-existing entity. But the court found that because there was, it was really representing the entity from day one. I think it's also an unpublished opinion
Mhm.
where perhaps unpublished because the court, didn't want people to rely on it on a go-forward basis, because it is a very specific fact scenario. But it does highlight the risk. I mean, even though the law firm was not found at fault, the case itself highlights the risk that one of the founders of a business may bring claims against you as the lawyer for the business
Mhm.
because you've somehow conveyed to them or let them reasonably believe that they individually were a client.
Yeah, and the law firm had one other good fact, in that they did have an engagement letter that basically was pretty clear that it was the
Yeah.
entity. So I
Yes.
don't know if the founders appreciated that, but it was in writing and they signed it. So they were, it's the one time a lawyer can actually contract with a client is right before they get engaged, right? After
Yeah.
that, you've got all these rules where they have to be advised to get independent advice, etc.
And
Um,
if I could just on that point, I think that is the language that's in the engagement letter that basically says we represent the entity and not any of the investors or shareholders or other founders. That's the language that should be in every form engagement letter when you're representing an entity. Make it clear who the client is
yeah.
and that nobody else is the client.
Yeah, I guess the tougher case, the thing we is harder to protect against is a scenario where now we form the entity and the board, of course, is controlled by the founders. And they say, gee, corporate counsel, we are instructing you as counsel to the company to do this thing that protects a stakeholder, a constituent, a shareholder. And oftentimes it's around tax, for example, do this thing that gets them a great tax result. Or maybe it's something, a clerical thing, file this 83B election for the founder. So they're instructing you to do something that benefits the shareholder. Shareholder is not your client, but in that scenario, absent something else in writing, I guess they're a third party beneficiary, aren't they? Yeah.
They are, and they may have a claim for negligence. I mean, it's similar to um, case law where somebody a client has a trust and estates lawyer and they instruct the lawyer to write up a will that benefits the client's children or somebody. um, in some ways that's similar to the board saying take these actions to benefit our executive. If the lawyer fails to satisfy the instruction that comes from the client, they could be the beneficiary has standing basically to sue for malpractice or negligence even absent an attorney-client relationship. But if the work is being done in such a way and the interaction with the individual is such that the individual thinks, I have an attorney. This attorney is doing work for my benefit, and I reasonably believe that we've formed an attorney-client relationship. Um, then there may be duties that are owed to that individual in addition to, the individual just having standing to sue.
Yeah. And by the way, just on that point, I mean, you always, without exception now, on that particular issue, filing an 83B, you see a complete disclaimer of that obligation in company documents. That's just the way we draft it because it's such an easy thing to miss. And, the company could have, one company could easily have 100, shareholders that need to file that form. So it's an easy thing to
Right.
miss. So you'll almost always see in the documents, we're not going to do this for you. And it's kind of interesting when I first started practicing. Well, of course we would do that for your shareholders. Every law firm in town would do those until, it's an easy filing that it doesn't get made on time. And it got missed enough times because it's something the paralegal would do and the lawyer might not even be aware. So
And
now
might
it's
not even
all
think about. Yeah.
wouldn't even think about it. And so now never, almost never. I mean, you would have to specifically ask a lawyer to do that. And that's the reason why, because you're creating all these obligations now for the company not even dimensional obligations for the company, that you're, by not saying anything about it. Anyway, I didn't want to
Totally
get
agree.
down a rabbit hole on that one example, but that's the one that I think is the perfect example. So let me ask you, I know we're kind of running out of time. Other than this ABA formal opinion, any other recent developments here in California or otherwise that are worth mentioning in this area?
I'm not aware of any. I have to say, in my role as a member of various ethics committees here in California, I have advocated several times for an advisory opinion on this very topic, and I've received a lot of pushback from practitioners who are concerned that whatever it is we say and dictate will be contrary to ordinary practice, um, and create a bad paper trail because attorneys, unfortunately, are not as careful as perhaps they should be on these issues. So I don't have anything. The one seminal case on this, though, is over 3 decades old, and it's almost kind of absurd in how it reaches a conclusion on these same fact patterns. But that's the one that gets pointed to all the time. Um, and it's not even a California case, it's a Wisconsin case. I'm sure you know the one I'm talking about from 1992. And it still gets cited as authority, uh, but all it's really saying is if there's an expectation that the entity is the client, then nobody else can possibly be the client. And that is not the practical reality of how founders and lawyers in this space really look at their attorney-client relationships.
Yeah. Okay. Well, thank you, Neil. I'm not sure that we cleared anything up today, but we certainly
I
did
doubt we did.
use. Um, and this is Roger Royce, 10,000 Startups. I've been talking with Neil Wertlieb from Wertlieb Law. I didn't even mention that you not only are you a professor at sounds like 3 universities on these issues, but you also have your own organization where you act as expert witness, I think you said, and you
Exactly.
okay, offer advice and also expert witness services at Wertlieb Law. So if people want to get a hold of you, they can Google that and they'll find you in Pacific Palisades. Okay, well, thanks again, Neil. I really appreciate you being here. Roger Royce, 10,000 Startups. We'll see you all next week.